Hello and welcome. My name is Sally Zarnowitz. I'm the Senior Preservation Planner for the City of Berkeley and a California Preservation Foundation trustee. Thank you so much for joining this webinar on CEQA and historic buildings and overview. The format for today's webinar will include an hour presentation followed by time for questions and answers, moderated by Executive Director Cindy Heitzman. There is a toolbar on the right side of your screen. If you have a question at any time during the presentation, please type it in the box and we will either reply to you or hold the question until the end for the panelists to answer. Please refer to the audio tab in the toolbar and select if you are listening through the telephone or speakers. To unhide this toolbar, click on the orange arrow. Please adjust your volume on your computer or phone. Today's presentation will be by Oconee Danielson, David J. Powers and Associates, and Amy Mintier with the law firm of Chatton Brown and Karstens. Oconee Danielson has over 16 years' experience in preparing environmental documents and planning. As a principal project manager with David J. Powers and Associates, Mr. Danielson provides management and oversight in the preparation of environmental documents required under federal and California laws, including environmental impact reports and environmental impact statements, environmental assessments, and initial studies. Prior to joining David J. Powers and Associates in 2010, he worked for the City of San Jose for 13 years, most recently as principal planner where he managed multiple planning division development work programs, including environmental review, historic preservation, urban runoff management, and development of the city's private sector green building policy. Mr. Danielson received a Bachelor of Science degree in Geological and Environmental Sciences from Stanford University and a Master's degree in City and Regional Planning from the University of California, Berkeley. Amy Mintier is a partner at Chatton Brown and Karstens, a public interest law firm located in Hermosa Beach, focusing on environmental, land use, municipal, and natural resources law. Chatton Brown and Karstens primarily represents environmental and community groups and nonprofit organizations. Much of the practice involves litigation under the California Environmental Quality Act, including numerous cases involving historic resources. Amy worked extensively on CEQA litigation that ultimately resulted in the preservation of the historically significant Lincoln Place apartment complex. Amy represents the Palm Springs Modern Committee in its quest to maintain the heritage of modern architecture in Palm Springs. She has written articles and lectured on environmental law and historic preservation. Amy holds an undergraduate degree in Natural Resources and Environmental Sciences from the University of Illinois and obtained her Juris Doctorate from the University of Michigan. Thank you again for joining us.
Thank you, Sally. So this is Oconee, and I'm going to speak from the perspective as a city planner and now as a consultant assisting planning staff in implementing the California Environmental Quality Act, or CEQA, when historic resources are involved in a project. The picture on this first slide, just as an aside, shows the Bank of America building under construction in downtown San Jose. And it's the most prominent historic office building in downtown San Jose. It's on the National Register, California Register, and is a designated city landmark. And it kind of begs the question, as you can see it there under construction with its superstructure, if CEQA had existed at the time, how might the impacts of this structure have been evaluated? And what was demolished to make way for this? It's just a question. So the next 30 minutes or so, I'll be covering about a dozen or so slides, touching on the objectives of the CEQA process, what sorts of projects are subject to CEQA, the differing CEQA processes, exemptions, initial studies, EIRs, and so forth, how a site and its surroundings are evaluated for the presence of historic resources, how impacts to historic resources are evaluated, and then opportunities or strategies for avoiding and mitigating impacts to historic resources, and then alternatives to projects that have significant unavoidable impacts to historic resources. The photo on this particular slide is of the city landmark Carnegie Library on East Santa Clara Street at 23rd in San Jose. It was constructed in 1907 and is also listed on the National Register and California Register. And as I'll discuss in the following slide, the city, back in 2007, undertook a project subject to CEQA involving this library. Okay, so what are the objectives of the CEQA process? This act was passed in the early 70s by the state legislature and was established for several reasons. First and foremost, to require that public agencies that were undertaking projects that would affect the environment would have to study, evaluate, and disclose the environmental effects of their projects. So disclosure is a key component of the law so that informed decisions can be made, and then the public agency decision makers can be held accountable for their actions by the electorate. The law also has a preference for avoiding environmental damage when it's possible. So by studying the effects of projects, projects can be redesigned to avoid them from the start. When avoidance isn't possible, public agencies need to look at ways to mitigate, to compensate, or to rectify the environmental impacts that they've caused. The Act also facilitates public participation by requiring various meetings, scoping meetings for EIRs as they're getting prepared. The Act also includes public review periods for initial study mitigated negative declarations and also for EIRs. So there's a public participation component that allows the citizenry to participate in the planning process by being informed of environmental impacts. And then lastly, through the environmental review process, public agencies can coordinate. So a lead agency, a city, let's say, that's reviewing a private development application can coordinate with the county transportation agency over the traffic impacts of that project, or with the State Department of Transportation, Caltrans, or for projects involving historic resources. If a lead agency doesn't have a great deal of expertise with historic resources, that agency can coordinate with the State Office of Historic Preservation. So through the environmental process mandated by CEQA, public agencies coordinate and share information and their planning efforts. So the photos on this slide, these are more pictures of the Carnegie Library. The slide on the left shows the original historic facade from 1907. This particular library was too small for current needs, and so back in 2007, the city undertook an addition of approximately 10,000 square feet. This was a project subject to CEQA. As I mentioned, the building is a city landmark. It's on the national and California registers, and so the impacts to it were an issue. So the addition was evaluated according to what are called the Secretary of the Interior standards, which we'll get to in a later slide. And as a result of that review and evaluation, the project was deemed eligible for what's called a mitigated negative declaration, which again we'll get into. So when does CEQA apply? So the California Environmental Quality Act applies to physical changes in the environment. The Act is not focused on social or economic changes primarily. There needs to be a physical change. So a public agency is looking to do something of its own that would alter a piece of property or the environment, or the public agency is issuing an entitlement for a private entity. So it's reviewing a subdivision for a housing development, or it's reviewing an application to construct an office building. There needs to be a change in the environment. And the environment includes historic resources. So included amongst air, water, land, biology, noise, historic resources are included within the scope of the Act. So there needs to be a public agency action, and that action can include an issuance of a permit or other entitlement to a private entity. Implicit within the law is that by studying the effects of a project's impacts on the environment, the lead agency has to have the ability to do something about the proposal based upon the information that is generated. So there needs to be discretion. If the proposal is what's called ministerial, it's a ministerial action, and examples of a ministerial action would include typically a building permit. If somebody wants to go make an interior alteration to an existing structure, applies for a building permit, the building official confirms certain mandatory objective criteria are met, and as long as they're met, the permit is issued. So that's ministerial. Grading permits often fall under that, that category as well. But if the public agency that's undertaking the activity itself or that is evaluating the private activity has discretion, meaning even if certain minimum basic requirements are met, the public agency has the ability to still say no or otherwise alter the proposal, then CEQA applies. So if the public agency has the ability to say no to the activity, the public agency needs to understand the consequences of saying yes to the activity. And so as I've mentioned, ministerial actions are those that meet certain minimum basic requirements. There's no discretion on the part of the agency. If the minimum basic requirements are met, the permit is issued, CEQA does not apply. In some instances, demolition permits can be ministerial. In some cases, they can be discretionary. In San Jose, if you are constructing a single-family house that doesn't otherwise trigger any basic requirements for a single-family house permit through the planning department, you get a building permit. It's ministerial. And if your project involves the demolition of the existing house on the site, if you didn't meet any of the triggers for a new single-family house permit, it's considered ministerial. It's therefore exempt from CEQA. It is often the case, though, that most new development in a given jurisdiction is going to be subject to some sort of discretionary process. So to build an attached unit product or to construct an office building or a retail space will trigger a planning permit. Planning permits are discretionary. They're subject to CEQA. So the implementation of that project through ultimate building permits and grading permits wouldn't in and of themselves trigger CEQA, but the underlying activity of the project itself had been subject to environmental review from the beginning. So in this particular slide, the image that's shown is of the Peralta Adobe in downtown San Jose at West St. John and North Almaden. And this structure was built in 1797. It's believed to be the oldest remaining structure in the city. It's designated as City Landmark #1. It's also on the National and California Register. So CEQA would apply to any actions of the city looking to alter the adobe or its surroundings, if it's a publicly owned building. CEQA would also apply to any private development activities that were occurring in the vicinity that were subject to a planning permit where the city had discretion. But as you can see in this picture, there's a building with a blank wall immediately west of the adobe. If all that's being requested are interior changes to that building that only require building permits, those would not be subject to CEQA because they're ministerial. So I'm sorry, a question that often comes up is, does CEQA apply to the interior of a structure? And there isn't a cut and dry answer. The answer is it depends. So in certain circumstances, CEQA can apply to an interior. And so we come back to the basic question, does the activity involve a change of the environment, a physical change of the environment? And in other instances, CEQA does consider the interior of a structure to be part of the environment. So for instance, for noise, if a project is being reviewed that would generate substantial noise, we would look to see whether it was be causing interior noise effects to surrounding properties. So building a roadway or approving some outdoor stadium, we would then be concerned about the noise effects to interiors of structures in the vicinity. So clearly, interior buildings, the interiors of a building can be considered part of the environment under certain circumstances. In the context of an historic building, the question would be, is there something about the interior that is integral to the historic significance of the structure? This particular image on this slide is of the interior of San Francisco City Hall. So they are very ornate. Lots of activities have occurred within that structure that have significance. So in this particular building, I would say yes, the interior of that structure is integral to its significance. So for CEQA to apply, assuming that the interior is considered part of the environment, the question would be, does the lead agency have discretion in the proposed changes to that interior? So for a public building, which is open to the general public, it would be considered part of the environment. Anybody can go in there. It's understood by the public at large. It's not just an individual single-family home that only the occupants of that building are going to occupy. It's owned by the city. It's owned by the public agency. So clearly there's discretion about whether and how to alter the interior. And so concern should be applied to any proposals to alter those features to make sure that the character-defining features that convey its significance are protected. In some instances, the lead agency may not have access to an interior. They can be off limits. So in the case of a public roadway project, the city or a county is looking to extend a road, and in doing so would need to acquire right-of-way, and within the path of that road and the right-of-way that would be acquired, there could be private structures, and those private structures may not be available to the public agency. The occupants of the structures may be adamantly opposed to the roadway extension and wouldn't want to facilitate that project in any way. So in that case, the public agency's evaluation of any of those structures for potential historic significance could only rely upon the exterior. So interiors can be part of the environment, can be subject to CEQA only under certain circumstances, and Amy will have a case, I believe, that speaks to this later in her presentation. So what are the primary processes under CEQA? So a public agency reviewing a project, so physical change to the environment, there is discretion. Projects qualify for certain processes based upon what's involved. There really are 4 main classes. There are those projects that are exempt by statute, statutory exemptions. The legislature has deemed them inapplicable. CEQA will not apply to these projects. There's no rationale necessarily other than the legislature did not want to. There could be a variety of reasons why, but they are not subject by law. Examples of these would include ministerial projects. If there's no discretion involved, there's really no point in studying the effects of a project. It becomes academic because you don't have the ability to stop the project or to require alterations. Projects which are disapproved, so if you're going to say no to a project, then you don't necessarily need to be aware of the consequences of saying yes if you're going to deny it outright. Projects that are an emergency, that are necessary to abate an emergency or prevent an emergency, you don't have time to study the environmental consequences. You just need to act. So those are exempt statutorily. Certain others, family daycare homes, pipelines under certain circumstances, closing a public school. There's a list that are in the CEQA guidelines of projects to which the act is not applicable. So regardless of whether they have environmental effects, it doesn't matter. The law simply doesn't apply. The rest of the projects that we're going to talk about are subject to CEQA. So there, the impacts of a project have to be evaluated and disclosed and mitigated where possible. There are classes of projects that qualify for what are called categorical exemptions. And there are, I believe it's 34 now in the guidelines, perhaps 35, different classes of projects that the legislature or the State Resources Agency has identified as projects that are routine and they typically don't have impacts. So generally speaking, projects of this type will not have an impact because they involve an existing facility with negligible or no expansion of use, or you're replacing or reconstructing a building or a facility with virtually the same size and function, or you're constructing or converting a small structure or structures. You're only making minor alterations to land. You're doing a minor land subdivision, infill development under certain circumstances, and projects involving historic restoration or rehabilitation that meet the Secretary of Interior standards. Those can all qualify for what are called categorical exemptions, meaning they are exempt provided that they don't appear to have the potential to result in any significant effects. So there is what's called an exceptions test that you would apply for a project that appeared eligible for a categorical exemption. And so this is CEQA Guideline Section 15300.2. And so there are a series of exceptions that would preclude a project from being eligible for a categorical exemption. They would kick them out of that process into a more involved, detailed process involving public review. So projects that, by virtue of their location, would have a significant effect. So, if you were going to construct a single-family house, that would normally qualify for a new construction of small structures. But if you were going to construct it on a fault line, that would be a location where you would have a significant effect, or in a sensitive habitat area, for instance. So there are certain instances where by location, a project would otherwise be categorically exempt cannot be found exempt. If your project would have a cumulative effect in combination with past, present, and reasonably foreseeable projects, it cannot be found categorically exempt. If the project would affect the scenic highway or be located on a hazardous waste site where there was soil or groundwater contamination, or if the project would substantially affect an historic resource in an adverse manner, that would also preclude it from being exempt. So again, categorical exemptions apply to many thousands of projects every year across the state of California, but there are instances where projects are ineligible because of the circumstances of that particular project would result in an impact, even though generally speaking that type of project would not. So if a project doesn't qualify for a statutory or a categorical exemption, then the lead agency would typically undertake what's called an initial study. And so the initial study will look at a broad range of environmental issues to see whether any of the impacts could be considered significant. So in an initial study, there's a checklist, Appendix G of the CEQA guidelines, where there are a number of questions involving issues such as aesthetics, agricultural and forestry resources, air quality, biology, cultural resources, so historic resources and archaeology, geology, greenhouse gas emissions, soil and groundwater contamination, hydrology, land use, minerals, noise, population, housing, public services, recreation, transportation, utilities, the gamut. All of the potential environmental effects of a project get evaluated in the initial study. And if the impacts are less than significant to begin with, applying applicable thresholds for each particular impact, or the impacts are significant but can be mitigated back to a level of less than significant, then the project can qualify for what's called a mitigated negative declaration. And this gets circulated for public review. It's a minimum of 20 days. If the project involves the approval or a permit from a state or trustee agency, it has to go through a 30-day review period through the state clearinghouse. And then at the end of that, the lead agency adopts it and can take it forward to the public hearing to approve the project. However, if a fair argument can be made that the project would have a significant effect, even after mitigation, the lead agency must prepare an environmental impact report. So I'll get into the fair argument, the definition of a fair argument in a slide or two, but basically an initial study mitigated negative declaration is subject to a fair argument test, and that's a very low bar to trigger an EIR. So an environmental impact report would be required whenever there's a reasonable possibility of a project having a significant impact, and the primary benefit of the EIR process would be the evaluation of alternatives. So in an EIR, you will cover the same basic set of topics we talked about in the initial study checklist, from aesthetics through utilities, but in addition to that, we're going to develop a set of alternatives that are at least potentially feasible, that can avoid and reduce significant effects while achieving most project objectives. So in the context of an historic resource, we'd be looking at ways to preserve that resource. The minimum public review and comment period for an EIR is 45 days. There is no public comment period for projects that are subject to an exemption, at least not required. Okay, so so the threshold question then for CEQA and historic resources would be, assuming that the project is subject to CEQA, does the project site or its surroundings involve an historic structure or an historic district? So there the lead agency would be looking to see, are there any structures on the site itself or in the vicinity that are listed in or eligible for the California Register and or its own local inventory if it has one. So the photo on this slide involves the Dianza Hotel, which is another historic downtown San Jose structure. This is on West Santa Clara, so sort of the western side of downtown, and you can see a sort of a before picture, an early picture from the probably the mid-30s, showing the Dianza there on the left. When San Jose was a much smaller city, its downtown was not that large at the time, and then over time the city grew up around it. So it's now been surrounded by a number of taller, newer buildings, and over time the structure has lost integrity of setting, even though it itself has never been touched by a demolition or a physical alteration. Its setting has now been compromised over time. Okay, so continuing with the question, are historic resources present? So again, first we would look to see, was it on an inventory or not? Let's say that the site does not have any listed resources, but there are structures on the property that appear to be at least 50 years in age, which is sort of the threshold age typically applied. So they're old, but they're not necessarily documented. So in that instance, the lead agency would engage an historian, qualified historian, to prepare an historic report. As a part of that analysis, they would research the date of construction and whether it's associated with any important people or events, and apply the California Register criteria. So is there something about the architecture or its method of construction that is distinctive and important to the history of the state or that locality, or is it associated with an important person or event? And so the Cal Register criteria are set there, applied across the state. There are local criteria that a given jurisdiction can choose to employ. So San Jose has its own criteria in Title 13 of the Municipal Code. The local agency can choose to have its own local criteria, and there the significance will be based upon the values of that jurisdiction. So as an example, San Jose in the past, in its criteria, had a minimum age requirement of 30 years. So San Jose had said that it needed to be at least 30 years in age for a property to qualify. That age criterion has since gone away, so there really is no minimum age anymore. But that's an instance of a local agency coming up with its own specific criteria to apply. So the qualified historian evaluates the structure, compares it against the state's Cal Register criteria, any local criteria that exist, and the results of that get documented in an historic report that then gets evaluated and vetted by the lead agency in the city, the county, whoever it is that's undertaking the project or reviewing the application. Because CEQA requires that regardless of who does the work, so in this case we're saying it's a historic consultant under contract with the city, the analysis needs to reflect the independent judgment of the lead agency. So regardless if the city staff did it or not, the city staff ultimately needs to agree with the conclusions on which it's going to base its environmental determination. So it gets vetted by the lead agency. So under CEQA, there are several different classes of historic resources. So there are certain that are considered mandatory. So those that are listed or are eligible for the California Register are mandatory. They have to be considered resources under CEQA by the lead agency. There are those that are considered presumptive. They're presumed to be resources. So those that are listed locally as significant. So in San Jose, city landmarks are considered significant resources under CEQA. And based upon San Jose's own values, there are certain criteria for a city landmark, and those are treated as significant for purposes of CEQA. There are other buildings that are discretionary under CEQA. So they may be listed, but at a lower level, or they may not be listed, and the city declines to consider them resources under CEQA. So these are what are called these are what are called discretionary. So there, the lead agency has the discretion about whether to treat them as resources under CEQA or not, but it's really a choice to be made. It's not mandatory. It's not presumed. And so there's a case from 2008 called Valley Advocates versus the City of Fresno that touched on this question. And this was a case where the City of Fresno was reviewing an application to demolish a building or two buildings. And the building was not listed, and the city had the discretion about whether to treat it as a significant structure or not. And if the building is not considered, if it's not listed, and the city chooses to not consider it a resource under CEQA, then according to this particular published opinion, the fair argument would not apply. So this photo on this slide shows a structure on the Alameda, which is the part of the historic El Camino Real, leading out of downtown, so west of the Hotel Diana that we saw on a previous slide. And this particular building was called the San Jose Tractor and Equipment Company, built in 1924. And so when the city was reviewing an application to construct a new Whole Foods market on the site, the city had to take into account whether this was an historic building. So we looked to see, is it listed on the Cal Register? It was not. Is it listed on the city's own inventory? It was listed as what's called a structure of merit. And the city, as I think I've mentioned, does not consider a structure of merit to be a resource under CEQA. So that's San Jose's own determination of how to apply its own local criteria. So the demolition of this particular building was not considered a significant impact under CEQA. No need for mitigation or preservation alternatives. And the underlying project, which was the demolition of this building and the construction of a new Whole Foods, qualified for the negative declaration. So let's say that we've got a site, though, where there are either listed or eligible historic resources. So there, the evaluation will need to focus on what are the character-defining features of the structure. Because then we're looking to see, well, if it's a demolition, then it's important to know what's being lost. Is it something about the architecture of the building or its association? That's important to know. But if the proposal involves a modification, so the proposal wouldn't demolish the structure altogether, but it might alter it. Or in the case of the Carnegie Library that we touched on in earlier slides, the library itself was going to stay, but there would be an addition to it. So it's important to know what are the character-defining features of the resource so that those can be preserved under any redesign of the project or mitigation. So the character-defining features are those features which convey its significance. It could be something about its roof or its facade or something about the structural system. That's something that the historic consultant would have to evaluate. For something to remain eligible to qualify for the Cal Register or for the local inventory, it must retain integrity. So that's, again, where the consultant, the historian, is going to focus on those character-defining features that convey its significance. Do they remain? Does it have integrity of location? Does the design still as it was when it was built or at its period of significance? Has the setting been compromised? We talked about the Hotel de Anza in a prior slide about how the world has grown up around it and its setting has been compromised. Are the materials still there? Is the workmanship that was important to its significance still present? Or its association with an important person or event? So integrity is a key question when we're talking about a building being eligible for the California Register or for a local, and then also for any proposed alterations to it. Would it retain integrity after what's proposed would occur? So enough integrity must remain for it to remain eligible. I mentioned before the concept of a fair argument. So when a project is undergoing an initial study process and trying to qualify for a mitigated negative declaration, as I mentioned, if it can be fairly argued that the project would have a significant effect, then you must prepare an EIR. So for something where an historic building it's debatable about whether it qualifies for the California Register, that would be subject to the fair argument. If there's a question about whether the proposed alterations to the structure would substantially affect its integrity, that's subject to fair argument. So the fair argument says, if it can be fairly argued based on substantial evidence that a project would demolish or substantially alter in an adverse manner an historic resource, you need to prepare an EIR. So this particular photo on this slide, sort of before and after, the left slide shows what was known as the Letcher's Garage, which is an historic building constructed in early 1900s in St. James Square Historic District, so just north of downtown in San Jose. And this particular building was listed on the National Register, California Register, and as a city landmark as a contributing structure to the St. James Square Historic District. So for purposes of CEQA, it's a mandatory resource. However, over time, there have been multiple alterations. So as it was originally a garage, it had been used for a variety of things up to and including the nightclub. And so over time, it was modified. The interior, certainly the exterior, as you can see in the photos, was substantially altered. So it did lose integrity of design and materials. However, given its location within the historic district and that its basic form still existed, it was evaluated as retaining sufficient integrity that it still contributed to the district. And so when the city was evaluating a proposal to allow its demolition and the construction of a new residential high-rise on the project site, it was considered a significant impact. And so therefore, the city prepared an EIR to disclose that impact and to consider preservation alternatives. So in this case, we were looking both at the loss of this individual structure as an impact under CEQA, and we were also evaluating the impacts of the new construction on the district as a whole, which consisted of about a dozen or so buildings. So with the introduction of a new building into that district compromises integrity. And in this case, the city's guidelines that were developed to protect St. James Square were implemented, and the new construction was not found to have a significant effect on the district. So we've talked about evaluating the structure. And if it's not already been documented and listed on the Cal Register or in a local inventory, it needs to be evaluated. And the results of that evaluation, does it qualify? Is it eligible for the California Register? Is it eligible as a local landmark? Or is it eligible at a lower level that's not considered significant under CEQA? Or is it not eligible for anything? So the evaluation will drive the CEQA process for that project. So if there is no resource present, then there's no potential for an impact. So there's no need for mitigation. And if you go back to our discussion about categorical exemptions and them being subject to the exceptions test, 15300.2 of the CEQA guidelines, the exceptions test, one of the exceptions was the project could not substantially alter or demolish an historic resource. And so if the answer after the evaluation is that no resource is present, then the exceptions test would not be met, and the project could still potentially qualify for the categorical exemption. If there is a resource present, so building listed or eligible for the California Register or considered significant at the local level, then there is the potential for an impact. So then the question becomes, what will the project do to it? Well, demolition would be an impact. Substantial alteration that would affect the character-defining features, cause a loss of integrity, that's an impact. Or relocating the structure either on-site or off-site to a location with an inappropriate context could also be considered an impact, in that it would be in an inappropriate setting and would have lost integrity of location. And as we talked about before, in some circumstances, interior alterations could also be considered an impact if the interior is considered part of the environment, and if the interiors have character-defining features that are integral to the significance of the structure, and most importantly, if the lead agency has discretion over those changes. So if resources are present and the project would have an impact, but there's feasible mitigation that would avoid that impact in a manner consistent with the Secretary of Interior standards, which we'll talk about in a slide or two, then the project should qualify, should be eligible for the initial study mitigated negative declaration, because with the mitigation that's proposed, the impact does not remain significant, and so therefore there shouldn't be a need for an EIR. However, if it can be fairly argued, or if there are no feasible mitigation measures to begin with because the proposal is demolition, then the lead agency must prepare an EIR, and in that EIR it must evaluate alternatives that would preserve the resource. And so whether we're talking about mitigation or whether we're talking about an alternative in an EIR process, the focus of that effort should be on ways that the integrity of the structure can be retained. Again, whether we're talking about not moving it or not altering the interior or the exterior, whatever the character-defining features that are being affected, how can that be mitigated or avoid altogether through an alternative? That should be the focus of the analysis. So what is mitigation for purposes of historic resources in CEQA? There are three methods of preservation. So you can preserve it by stabilizing, protecting, maintaining, and repairing the structure. You can rehabilitate it through repair, alterations, or an addition. You can restore it by removing non-significant or non-original features and preserving and reconstructing missing features. So any of those options that are done consistent with the Secretary of the Interior standards would be considered to have a less significant impact on the resource, and therefore the project should qualify for an initial study mitigated negative declaration, or if it fit with one of the categorical classes, it might be found exempt. So relocation is another potential mitigation option that's available under certain circumstances. So moving the resource would be considered a less desirable outcome than preserving it where it was, but it may be an option. And it can be a way to avoid a significant effect if it's moved to an appropriate offsite location. So there are certain practical issues. Is the building capable of being moved? Does it have structural integrity? Will it survive a move? Or is it just simply too large, that there's not space available to move it off-site, down a road, under an overpass, across a bridge? You know, there just may be physical limitations in the ability to move it. But assuming that structurally it can be done and physically it can follow whatever path is necessary to find the new home, it would then need to move to an appropriate historic context. So you couldn't take a Queen Anne Victorian from the late 1800s and move it into a mid-century modern neighborhood and find that consistent in terms of the historic context. So there would be a loss of integrity, both of location and setting in that instance. So relocation is an option, but only under certain circumstances. And then finally, there's the possibility of recordation, and this is documenting the structure that's been lost. However, this is not sufficient to avoid a significant impact under CEQA. This has been established for approximately 2 decades now in the Montgomery Ward case in the city of Oakland, where the city of Oakland had, or the school district I think it was, had actually proposed archival documentation as a way to mitigate, and found the project eligible for a mitigated negative declaration. So they found that by simply documenting the resource, you didn't need to do an EIR. That was challenged in court, and the court disagreed. So you cannot mitigate to a less than significant level simply by archiving. Okay, so finally, last slide. We're at a situation where it can either be fairly argued that the project should have a significant effect, or there really is no mitigation to even talk about, that the proposal is demolition at that point. You're in an EIR process. And so as I mentioned before, in an EIR, the primary benefit of that process, in addition to the extended review time, would be that the lead agency has to consider alternatives that would avoid an impact while simultaneously achieving most project objectives. So the idea is to consider a range of alternatives that are at least potentially feasible that would retain the resource. So it could be that the project, the site layout itself could be modified in a way that the building that was otherwise going to be demolished could be retained while still constructing the project that was proposed. So the site layout could be modified if the site was large enough. Alternatively, the building that's proposed on the site could be modified. So if it's a low slung building with a large footprint, you could consider constructing it with a smaller footprint and multiple stories as a way of compressing the footprint of the project and allowing the historic building to remain. Those two could be used in combination, of course. You could pursue an alternate layout and an alternate building design that together could preserve the resource while still accommodating the project. If those have problems, you could look to see, will the historic resource itself lend itself to that use? So if the proposal was to, you can see the Hotel De Anza on this slide here. If the proposal was to demolish the Hotel De Anza and replace it with a residential building, could the Hotel De Anza itself be converted to a residential condominium use, as an example? So can the historic structure itself be adaptively reused would be the question. And then finally, if the site is particularly constrained, you may look at developing a smaller project itself. So if because of the scale of the project, it's difficult to come up with an alternate site layout or an alternate building design or an adaptive reuse of the structure to accommodate the use itself, could the project itself be reduced in size? Could it be cut by some percentage such that that smaller project with those reduced objectives could be accommodated while still retaining the historic resource? So the images on this slide, again, depict the De Anza, which I've talked about before, Hotel De Anza on West Santa Clara. The context for this has been lost over time. The integrity of setting has been lost as the city has grown up around this building. This used to be the most prominent building in its local setting. It was the dominant structure on the skyline, but over time office buildings have grown up around it, and the project that was at issue 5-6 years ago was the addition of a new residential tower on the same block as the De Anza. And this tower was going to be 75 to 100 feet taller than the De Anza, was going to dwarf it and was going to further diminish its stature on the skyline. And so the De Anza is on the National and California Register. It's a designated city landmark. There was no direct impact to any of the fabric of the building itself, but the city found that the addition of this larger structure on the same block was going to further diminish the prominence of the De Anza, and therefore that was treated as a significant effect. And so as a part of that analysis, well, an EIR was prepared to disclose that, in addition to the loss of the historic building on the footprint of the proposed housing as well. But for purposes of the De Anza, there was an alternatives analysis that looked at ways that the new construction could occur without substantially detracting from the prominence of the De Anza. So that was, we looked at a site layout, we looked at building design, and then we looked at reduced scale as ways to lessen the effect on the setting of the Hotel De Anza. So with that, I'm done with this portion of the presentation, and so now I'm going to hand it over to Amy Mintier, who will cover CEQA case law involving historic resources and an update on pending CEQA legislation.
Thank you, Oconee. This is Amy Mintier, and I will be addressing several significant CEQA cases that deal with how and when CEQA projects, how and when CEQA protects historic resources, and then, as Oconee said, pending CEQA legislation. So the first question is, which projects require environmental review? And more specifically, how have courts determined whether a project is discretionary or ministerial? And this is an important distinction because, as Oconee mentioned, CEQA applies to any decision to approve a discretionary project, whereas ministerial projects do not require environmental review. So discretionary project approval requires the agency approving the project to exercise its subjective judgment, and the agency also has the authority to impose significant conditions on the project to reduce its impacts. A ministerial project, on the other hand, includes an approval that requires only that the agency ensure the project conforms with the objective standards set forth in a statute. There is no subjective discretion or judgment to reach such a decision, and they do not have the ability to impose significant conditions on the project. So an example to probably overly simplistic example to give you an idea of the difference between discretionary and ministerial approvals. If, for instance, a city has a billboard ordinance that limits the size of billboards but sets no other restrictions on billboards for the city, an approval of a billboard under that ordinance would be a ministerial approval, because determining whether the sign is within the size limits is an objective decision that doesn't require the agency's discretion. However, if the city's billboard ordinance included both a size limit and a requirement that the billboard be found to be visually appealing and not impact the surrounding community, those decisions require the exercise of judgment, and the approval would then be discretionary. Additionally, when a project involves an approval that contains both elements of a ministerial action and a discretionary action, the project should be deemed to be discretionary and subject to the requirements of CEQA. So for example, a project that includes both demolition of an existing structure, which could be ministerial, and the construction of a new large development that is discretionary, CEQA review would be required for the entire project, including both the ministerial demolition and the discretionary building portions of the project. Sorry about that. Determining where to draw the line between discretionary and ministerial approvals can be confusing. Courts have looked at the general CEQA principle of affording fullest protection to the environment as requiring doubts to be resolved in favor of a determination that an approval is discretionary and thus requires CEQA review. A determination of whether an approval is discretionary or ministerial often arises with regard to the issuance of demolition permits for historic resources. These decisions have been made on a case-by-case basis and rely on a careful review of the city or county's municipal code section applying to the issuance of the demolition permit. Many jurisdictions have code sections that specifically address demolition permits for historically designated buildings within the jurisdiction. There are two CEQA cases that deal with this issue in depth, and they resulted in differing conclusions. First is the Friends of Juana Briones case, and throughout the rest of the slides I've tried to include photos of the resource in question when discussing the cases. In this case, Juana Briones de Miranda built an adobe home on her Palo Alto ranch in 1840, and it was later listed by the city of Palo Alto as a city historic landmark. Juana Briones' adobe home had been preserved for many years, but in the 1990s the condition of the home had deteriorated and new owners decided to demolish the home. They were not proposing a replacement home or any other development in the place of the home. They were just looking to demolish the home with no replacement project. So the question at issue in this case was whether the issuance of a demolition permit for an historic home was discretionary or ministerial under the specific provisions of the Palo Alto Municipal Code. So to understand to look at the answer to that question, we need to look at what the Palo Alto Municipal Code provided. And it provided that prior to the issuance of a demolition permit for an historic resource, there was a mandatory 60-day delay of demolition, during which time the issue was to be referred to the city's Historical Resources Board. The Historical Resources Board then had the authority to provide an additional stay of demolition for up to 1 year. The question looked at by the court was whether this delay of demolition provided in the municipal code was enough to render the approval of the demolition permits discretionary instead of ministerial. And in this case, the petitioners argue that the delay was intended to provide time for the consideration and the development of alternatives to the demolition of the historic resource, and thus should make the approvals to be considered discretionary. This court disagreed with this argument and found that the city had no ability to impose conditions on the demolition permits and had no discretion to prevent the issuance of the demolition permits if objective prerequisites were met. And these prerequisites were that, one, the tenants, if there were any in the historic resource, must be notified prior to the issuance of demolition permits, and two, that that any historic residences must be vacant before demolition can take place. Therefore, the court determined that the permits were ministerial approval and CEQA review was not required for these demolition permits. The decision in Friends of Juana Briones' case is somewhat in contrast to the ruling in an earlier case, San Diego Trust and Savings Bank versus Friends of Gill. In Friends of Gill, the San Diego Municipal Code provided an automatic stay of demolition permits for historic buildings. The code also specifically stated that during the stay, the Historic Site Board was to investigate alternatives to demolition and confer with the owners of the site regarding the feasibility of alternatives to demolition. The court in this case found the issuance of the demolition permit to be a discretionary approval because the requirement of the municipal code to investigate and confer with the owner implied the city had the power to secure alternatives to demolition and to deny a permit if there was a feasible alternative to demolition. The court in Friends of Juana Briones' case also distinguished the Friends of Gill case because the San Diego Code included a specific statement that the Historic Site Preservation Board shall take such steps within the scope of its powers and duties as it determines are necessary for the preservation of the historical site. And the court in Friends of Juana Briones determined that this was the source of the city's discretionary power to condition or deny the demolition permit. So as stated by the court in Friends of Juana Briones, the test as to whether an approval is discretionary or ministerial comes down to the question of whether the municipality has the power to deny or condition the demolition or to otherwise modify the project to mitigate the impacts to the historic resource. Now, these two cases demonstrate there's a very fine line between what's considered ministerial and what's considered discretionary, and there is a difficulty in determining the difference between these two types of approvals. So each require a careful review of the individual jurisdiction's code sections, and it also indicates a need for cities to carefully craft sections regarding demolition of historic resources so that it's clear whether a discretionary or ministerial approval is desired. So earlier, Oconee addressed the general requirements with regard to the consideration of impacts to the interiors of historic buildings under CEQA. And so I'm now going to discuss the one appellate CEQA case that addresses this issue. That case is the case of Martin versus the City and County of San Francisco. And the resource at issue in this case was the Atkinson House in San Francisco, which is a designated city landmark and part of a historic district. It included redwood interiors that were designed by architect Willis Polk, and those redwood interiors had been identified as a contributing feature to the historic designation of this home. The Atkinson home is a private single-family residence, and the owner of the home submitted plans to the city to remodel portions of the exterior and interior of the home. In reviewing the remodeling plans, the city had no problems with the alterations that were proposed for the exterior of the home. However, the city required CEQA review of the alterations because it determined alterations to the interior of the home would cause substantial adverse change in the significance of a historical resource. And this was the first time that the city had required CEQA review for the alteration to the interior of a single-family home. And as you can see in this photo on the slide, the interior was not visible from the sidewalk. The home was set back from the street, and it was not visible from any other public space. The owner of the home, Martin, brought an action claiming CEQA review did not apply to this project. And in looking at whether CEQA review applied or not, the court did not determine whether the approval of the permits to alter the interior were discretionary or ministerial. Instead, the court addressed the more fundamental question of whether a municipality could require the owner of a private single-family residence who proposes to modify a portion of the interior of his residence in an area not visible to the general public to undergo the burden and expense of review of his proposed project under CEQA. And to answer this question, the court looked at a lot of different aspects of CEQA. It looked at the general purpose of CEQA. It looked at that CEQA includes what is called the common sense exemption to environmental review, which provides that environmental review is not required for any project where it is clear there would be no significant environmental impact. And it also looked at the fact that CEQA includes categorical exemptions to CEQA review for single-family homes and alterations to homes. So in looking at all of this, the court determined that CEQA only applies to projects which have the potential for causing a significant effect on the environment. And a significant effect on the environment means a substantial or potentially substantial adverse change in the environment. The court found that to have a significant effect on the environment, the effect must be physically perceivable by members of the public beyond the private individual proposing the project. Thus, because the proposed alterations were to the interior of an existing single-family home and not perceptible to any other members of the public, the court found that the alterations lack the potential for causing a significant effect on the environment, and thus CEQA review was not required. In reviewing the case, the court also noted that the city itself did not require a certificate of appropriateness for alterations to the interior of privately owned landmark buildings. And the requirement for such a certificate would have provided the city with the ability to condition the alterations even if CEQA review was not required. The court did find that the city may have discretion to condition or deny alterations to interiors of private historic buildings through other city regulations that allow the city to ensure the public health, safety, and welfare, even if CEQA review was not required. The final area of case law I'll be covering is several cases that address the feasibility of alternatives to projects that would adversely impact historic resources. And as an overview to start with, CEQA requires that an agency approving a project that may have a significant impact on the environment make certain findings. The agency must either find that all impacts have been reduced to a less than significant level through the implementation of mitigation or changes to the project, or that less impactful alternatives are not feasible due to economic, legal, or other considerations. And if an agency finds that a less impactful alternative is not feasible, it must prepare what's called a statement of overriding considerations. And the statement of overriding considerations must provide the specific reasons why the less impactful alternative is infeasible, and those reasons must be supported by substantial evidence. The statement of overriding considerations must also set forth the benefits that would be derived from the project that justify approving a project with significant adverse impacts. There are several recent cases that have addressed the issue as to what is required to adopt a statement of overriding considerations for projects that would adversely impact historic resources. The first case is Preservation Action Council versus City of San Jose. And in this case, the proposed project included the demolition of an historic IBM building and the development of a Lowe's Improvement Center on the site where the historic building had been located. The EIR considered an alternative that provided for preservation of the historic building by reducing the size of the store. And the city rejected this alternative for providing preservation of the IBM building based on a finding that the alternative was infeasible because it would reduce the size of the store, which according to representatives of Lowe's would put the store at a competitive disadvantage. The court found that substantial evidence of economic infeasibility was required before a less impactful alternative could be rejected. And the court found that that statement by the project proponent that Lowe's did not want to build a smaller store because it would be less profitable was not substantial evidence of the alternative's economic infeasibility. The court also found that the claim that the reduced-sized project would be less profitable is inadequate evidence of economic feasibility because the reduction in profitability is not, in and of itself, an adequate basis for rejecting a less impactful alternative. The reduction in profitability must be so severe as to render it impractical to proceed with the project, not just less profitable. And in other CEQA case contexts, that's been shown through letters from a bank that it would not provide a loan for the project because its rate of return would be so low. And that kind of evidence is what's required to show the it's impractical to proceed with the project. The next case is Uphold Our Heritage versus the Town of Woodside. And in this case, the proposed project was the demolition of the historic Jackling home. The EIR was prepared to analyze only the impact of demolition of the Jackling house, despite the fact that the demolition was being done to facilitate the construction of a new, smaller home in its place. The EIR included analysis of preservation alternatives, including on- and off-site preservation of the Jackling home, and cost estimates for these alternatives were also included. The cost estimates were between $5 and $10 million for these alternatives. The town prepared a statement of overriding considerations rejecting the preservation alternatives as economically infeasible based on the cost estimates for these alternatives being significantly more than the costs associated with demolition of the home. The court reviewed this and found that first, the EIR should have considered the whole of the project, including both the demolition and the construction of a new home in its place. And the failure to consider both of these aspects of the project made the comparison of the alternatives inadequate. The statement of overriding considerations could not reject the preservation alternatives just because they were expensive. Comparative economic data was required, comparing the expense of the demolition plus construction of a new home to the expense of the preservation alternatives. The court further confirmed the holding in Preservation Action Council that the added expense or lost profitability of an alternative is not an adequate basis to reject the alternative without a showing that the added expense renders it impractical to proceed. The court also found that the less impactful alternatives could not be rejected as infeasible because even though the town could not force the proponent to implement the preservation alternative, the town still had the ability to reject the proposed project. And as a follow-up to the decision in this case, after the court's ruling, both parties explored ways to make the preservation alternatives work, in particular moving the historic home off the project site. However, due to the expense associated with this moving of the home off-site, the town and the homeowner proceeded to revise the findings under CEQA to allow demolition of the home. Economic data was prepared analyzing the expenses associated with the preservation alternatives as compared to the expense of the demolition plus new construction. And the town found that the difference in these expenses was so significant that it was rendered impractical to proceed with the preservation. And the trial court upheld the new statement of overriding considerations because it was based on the specific economic data. So unfortunately, after the revised analysis, the Jackling house was subsequently demolished. The Flounders Foundation versus City of Carmel case differs from the other cases because demolition was not the issue here. In this case, the historic resource was the city-owned Flanders Mansion, which is listed on the National Register. And the primary objective of the project was to divest the city of the mansion, which was in need of significant and expensive repairs. The approved project included the sale of the mansion and more than an acre of parkland surrounding the mansion. The petitioners in this case objected to the rejection of a lease alternative, which was found by the city in its EIR to be less impactful because the city could then ensure preservation of the historic mansion if it was only leasing the building instead of selling it outright. The city rejected the lease alternative as economically infeasible based on an economic feasibility report that found it would cost more than $1 million to restore the property if the city retained ownership, and that there was a very limited market for a lease of this type of property, which would mean it would be many years before the city could recover the costs associated with restoring the property. The economic feasibility report was based on what the court found to be an extensive review of the real estate market by experts in this field. The report also estimated that the sale price of the Flanders Mansion would be around $4 million, and the court found that this economic analysis was substantial evidence that the lease alternative was economically infeasible. The court also found that the economic evidence relied upon to reject the lease alternative did not need to be included in the draft DIR. It could be included in a separate report prepared after the draft DIR had been circulated. So that is the final significant case that I'm talking about today, and now I'd like to address a topic that's been a pretty hot topic for the past year, and that is a review of currently pending legislation that would make changes to CEQA. The first bill, and this is the broadest and probably most closely watched CEQA bill, is Senate Bill 731, which includes numerous measures to change CEQA with a stated goal of streamlining CEQA review. First, this bill would create thresholds of significance for key impacts such as noise within transit priority areas. And transit priority areas are defined in this bill as areas within a half mile of an existing or planned major transit stop. It would also eliminate the ability to find that a project has a significant aesthetic impact if the project is located in transit priority areas. It would require that an agency prepare annual compliance reports for mitigation monitoring programs to ensure that mitigation measures that were adopted through the CEQA process are being complied with. It would also require that the administrative record for a project be prepared concurrent to the agency's consideration of the project, which would help CEQA cases move forward more quickly through litigation. It would further require that when a court issues a writ of mandate finding that an agency's approval of a project violates CEQA, the writ would need to specify actions needed to bring the project approval into CEQA compliance. It couldn't just say that the project approval is overturned. Specific items that needed to be addressed would need to be included in the writ. The status of Senate Bill 731, it was approved by the Senate, and it is now in the Assembly. It passed out of the Assembly Natural Resources Committee, and CPF has been following this legislation and has been working with legislators to ensure protections to historic resources remain when changes to CEQA are being made. And I am happy to report that an amendment was added on July 1st at the urging of CPF that would allow for the consideration of aesthetic impacts for projects in transit priority areas if an historic or cultural resource may be impacted by the project. The next stop for this bill is the Assembly Committee on Local Government. Currently, the Assembly and Senate are in recess until August. However, it is expected that changes and amendments are being shopped around during this recess period. And on that on that point. Senate Bill 787 is another bill that was previously proposed that would have essentially gutted CEQA review by eliminating CEQA review for any project if the project complies with any other environmental laws or is consistent with the general plan for the area. This bill failed to make it out of committee in May. However, during the current recess, those that are in support of the limitations that would be placed on CEQA by Senate Bill 787 have been meeting with Assembly members in an attempt to add features of 787 into Senate Bill 731. In addition to Senate Bill 731, there are several other CEQA bills that are currently under consideration. First is Senate Bill 436, which would require an agency to hold at least one public scoping meeting for projects that would impact state highways. And right now this is up for an Assembly vote, floor vote, after the recess. Assembly Bill 417 is also being considered, which would provide an exemption from CEQA review for any bike transportation plans that are located in an urban area. And this bill is to be heard next by the Senate Appropriations Committee. Assembly Bill 52 would define impacts to tribal resources as significant effects under CEQA. And it is to be heard by Senate committees after the recess. In addition to these bills that are currently being considered, there are several two-year bills that are currently inactive but could become law in 2014. The first of those is Senate Bill 543, which would require translation of CEQA notices in areas where 25% or more of the impacted community has a limited ability to understand the notices in English. Assembly Bill 380, which would require electronic posting of all CEQA notices at the Governor's Office of Planning and Resource website. And Assembly Bill 953, which requires CEQA review of significant effects from locating a project near an existing hazard. And the purpose of this bill is to address the holding in the Ballona wetlands case, which found that the impacts of the environment on the project, such as impacts associated with sea level rise due to climate change or impacts of locating a project on a seismic fault, did not need to be considered under CEQA. So under this bill, it would make clear that those impacts do need to be analyzed as part of CEQA review. Senate Bill 617 would also specify that the impacts of the environment on the project do need to be considered, and would also include the electronic posting of notices requirement that is included in Assembly Bill 380. And the final bill is Senate Bill 754, which includes several provisions that would strengthen CEQA's protections. It would restrict project proponents from being the entity that prepares the environmental review document for under CEQA. It would establish a shelf life for an EIR, and it would specifically provide that the public would have the ability to enforce mitigation measures that have been imposed through the CEQA process. And this is current as of a few weeks ago when the recess started, but if others are interested in more information on the current status of bills, I would recommend going to the Planning and Conservation League's website at pcl.org, and they do keep a very up-to-date list of pending CEQA legislation. And thank you. I think we will now take any questions that anyone may have.
Thank you, Amy. This is Cindy Heitzman. We do have a question that was submitted a little while ago, and this relates to a single-family dwelling with minor rehab changes proposed. If the dwelling is associated with a significant person and is eligible for state and federal registers, would this building, this dwelling, be subject to a categorical exemption or a negative declaration?
Well, I can give an initial opinion on that, and then Akoni can put in his 2 cents as well. Under the categorical exemptions, there is a specific exception when a project may impact an historical resource. And so because it sounds like this project would impact a historic resource, a categorical exemption it would be unlikely a categorical exemption would be allowed to apply to this project.
Okay. This is Akoni. I guess I would ask a couple follow-up questions for the basics of the project itself. So it sounded like there were minor changes proposed. Are the changes subject to a discretionary permit by the lead agency, or is it ministerial? So does this CEQA apply at all? So assuming that this is discretionary, then as Amy mentioned, the city or county reviewing this would need to see whether the exception that Amy was mentioning applied. There is a categorical exemption for projects, for historic rehab projects that meet the Secretary of the Interior standards. So I think it would depend upon, okay, did the lead agency have discretion, and were the changes going to cause a substantial adverse change? So if what was proposed was going to be rehabbing or restoring the structure in a manner consistent with the Secretary of the Interior standards, it could qualify for that categorical exemption, which is number 15.331, historical resource rehab restoration. There's a class specifically for projects that are going to meet the standards. So the answer depends. Is what they're doing consistent with the standards? I think would be the substantive question.
Okay. Well, there are no other questions from the attendees, so just if anyone has a question, send it in quickly. But there are no other questions posted yet, so I would like to thank everyone for joining us today. And I especially want to thank Sally Zarnowitz, Akoni Danielson, and Amy Mintier for giving their time today to lead this webinar. You will receive an email with a link to a survey, and we would appreciate any feedback on this webinar and recommendations for future topics. Next month, we'll be holding the second part of this presentation on CEQA with a webinar titled Commenting on CEQA Documents. It'll be a 90-minute webinar on August 13th, and we hope you can join us. And we hope to see many of you tomorrow at our CEQA workshop in San Francisco, which will be followed by a workshop on the Secretary of the Interior Standards and assessing historic integrity. If you're interested in attending and haven't registered, please contact our office directly by phone 415-495-0349. If you're not a member of the California Preservation Foundation, we would encourage you to join as an individual, nonprofit, government, or a corporate member. Each member receives benefits, including discounts to all of our programs, such as the webinar you're attending today, all of our workshops, conference, and our Design Awards programs. It also qualifies you for attendance at our members-only tours. The discounts from 2 webinars would cover the cost of membership alone. Your attendance in this program helps us fulfill our mission to provide leadership to protect California's historic sites and communities through our education and advocacy programs. Membership information is available on our website. I want to thank you for your support and hope you have a good afternoon.